Good evening, everybody, and thank you so much for joining us. My name is Aquila Maliekel, and I am the president of the Virginia chapter of the Federalist Society. The UVA student chapter is honored to host the last in a wonderful series of events. For the past 10 Tuesday nights at 8, the student division has hosted a Zoom series called Challenges to Originalism, featuring a rotating cast of student chapter presidents from across the country interviewing originalism expert Professor Lee Strang. In that, he has laid out 10 of the most common criticisms of originalism from both the left and the right, and responded to some of the legal theory's most formidable foes, followed by a live audience Q&A. Today is the final challenge. Is living constitutionalism superior to originalism? All audience members should feel free to submit questions via the Q&A feature on Zoom. But first, to introduce our originalism defender, Professor Strang. Professor Strang joined the faculty of the University of Toledo in 2008, was granted tenure in 2010, and named the John W. Stopler Professor of Law and Value in 2015, and appointed the founding director of the Institute of American Constitutional Thoughts and Leadership in 2023. He was previously a visiting professor at Michigan State University College of Law, a graduate of the University of Iowa College of Law and Harvard Law School. Professor Strang clerked for Judge Alice M. Batchelder on the Sixth Circuit Court of Appeals and practiced law at Jenner & Block, LLP. Professor Strang has also been a visiting scholar at the Georgetown Center for the Constitution and a visiting fellow at the James Madison Program at Princeton University. A prolific scholar, Professor Strang has published dozens of articles on constitutional law and interpretation, religion, and the First Amendment. His most recent book, Originalism's Promise, a natural law account of the American Constitution, is the first full-length book natural law justification for originalism. He is currently editing the third edition of his casebook, Federal Constitutional Law, and finishing a book on the history of Catholic legal education in the United States. Professor Strang has lectured globally, is a frequent presenter at conferences, and regularly participates in debates, media commentary, and speaking engagements. In 2022, he convened the first symposium on common good constitutionalism at Harvard. Thank you so much, Professor Strang, for being here.
Aquila, thank you for hosting the last in the series. In some ways, this is a culmination of what's come before. And so I think part of our conversation tonight will be able to tease out some of the differences between living constitutionalism and originalism as two families of theories. So thanks for guiding us tonight.
Of course, very happy to help whatever guidance I may be able to offer. And I think actually it's probably good to start at the broadest question. So could you first take us to what is living constitutionalism?
Yeah, I think that's a great place to start. It's actually been lying in the background of a lot of the conversations we've had over the last 9 episodes before today's 10th episode. And one way to think about living constitutionalism is to define what it's in opposition to, or what it's frequently considered to be in opposition to, and I think rightly so. So when you think about originalism, the originalism tends to have 4 key characteristics, 2 of which living constitutionalists often reject. So one key characteristic of the different versions of originalism that are out there is called the fixation thesis, which is the idea that the Constitution's meaning is fixed when the Constitution's text is ratified, so 1789, 1791, et cetera. Second is the constraint principle, which is the idea that the officers of the United States who are sworn to uphold the Constitution in their official capacity should be constrained by that fixed original meaning. Third is the public meaning thesis, which is the idea that the Constitution's fixed meaning is its public meaning at the time of its ratification, and there's some subcomponents to that, but that's the kind of overarching view. And then lastly is the commitment to the proposition that there is constitutional underdeterminacy. That means sometimes the original meaning doesn't answer all legal questions. And so what living constitutionalism does is it often rejects, especially the fixation thesis, but sometimes and less frequently the constraint principle. So think about some of the cases that you probably covered in constitutional law. So when you look at a lot of the cases, especially during the New Deal period, but also during the Warren Court period, cases that come to mind are the Home Building and Loan versus Blaisdell case, which was a very creative interpretation of the Contracts Clause. And that's arguably a case where the Supreme Court, I would say, close to explicitly said that there was fixed original meaning back in 1789 that the Supreme Court was not going to follow in the Home Building and Loan versus Blaisdell case. What was that fixed meaning? It was that states can't impair the obligation of contracts. What happened in Blaisdell? If you've read the case, you know that the court said, so long as Minnesota has a sufficiently good reason, it can in fact impair the obligation of contract for some period of time. And so the Supreme Court, in some cases, at least implicitly and close to explicitly in some cases, has not followed the fixed original meaning. And that's a common theme among scholars as well. And I'll mention some scholarly works for our audience if they're interested in reading further on this so that they can see for themselves. There's less explicit rejection of the constraint principle. And I think part of the reason for that, certainly among the Supreme Court, so I'm not aware of a Supreme Court opinion where the court majority has said the original meaning is X and we're not following it. I think the Blaisdell case comes close to it, or maybe the closest to it, but otherwise, most scholars, most lawyers who've read constitutional law cases, they perceive there being a difference between the original meaning and then the court's operative interpretation. So it seems like they're doing something other than follow the original meaning. And I think there's a sociological reason for why justices historically and currently are hesitant to expressly reject following the Constitution's fixed original meaning. And that is, I think it's sociologically unacceptable, certainly today, and even during the kind of the high point of the Warren Court era, it was, I would say, acceptable for scholars to say it in some context, but I'm not aware of courts saying it, at least blatantly or patently. And I think especially today with the rise of an originalist culture, even among purportedly non-originalist justices, so like Justice Kagan in her confirmation hearings characterized herself, and actually characterized everybody, we're all originalists now, as following originalism. So living constitutionalism typically views the Constitution's meaning as not fixed, that it changes over time. Now, living constitutionalism, like originalism, is actually a family of theories. There's lots of different versions of living constitutionalism, and what unites them is their rejection of the fixation thesis and to a lesser degree, the constraint principle. There's actually a set of hybrid theories out there as well, Aquila, and the hybrid theories try to do both, right? So try to do some living constitutionalism and originalism. And I think the most prominent example of that is the work by Professor Jack Balkin, the book Living Originalism, and the title kind of gives it away, right? The title is, there's both originalism going on, and so Professor Balkin has a view that many parts of the Constitution, especially the structural parts of the Constitution, have fixed original meaning, but that for most of the operative constitutional law in the United States, that's the product not of interpretation of the original meaning, but instead of something different called construction, it's where the original meaning doesn't constrain the outcome of a case, and the Supreme Court, following popular constitutional movements, has created constitutional law. So I had promised to give some different examples of different living constitutionalists. I think that when you look at different living constitutionalist scholars over the last 30 or 40 years, I still continue to think that Ronald Dworkin's work, Law's Empire, is probably the best example of it. Freedom's Law is another example of his work. And so Ronald Dworkin had what he called the moral reading of the Constitution, which was you take the text of the Constitution and you identify the morally best interpretation of that text and the surrounding Supreme Court practice. And so as an example, what you would do is you look at the Equal Protection Clause, you look at the Supreme Court's precedent interpreting it, and you'd ask, what's the morally best interpretation of equal? And he had his own interpretation, which was a thoughtful, reasonable one, which he characterized as equal concern and respect. Another common living constitutionalist, in fact, I think one of the more powerful ones, is by David Strauss, called The Living Constitution. And Strauss's theory of living constitutionalism is really common law constitutionalism. So the Constitution includes the written text, but primarily over time, it includes this body of precedent that has been built up beyond that text and in addition to that text. I would say another example that I think some people have found persuasive is a series of books by Bruce Ackerman, the We the People series. There's now 3 books in that series. I think actually no, there's a 4th book in that series. And his theory is that there's the written Constitution, and then during certain constitutional moments, there are unwritten constitutional amendments to that. They can be in the form of Supreme Court precedent, they can be in the form of constitutional statutes, and they can be in the form of other practices as well. So what each of these different living constitutionalists have in common is they reject the proposition of there being fixed original meaning, and that there are other mechanisms of evolving meaning that then are utilized primarily by the Supreme Court to interpret the Constitution. So I think that's what characterizes living constitutionalism.
Okay. You said that judges have been somewhat reticent to come out all in all as living constitutionalists, and you provided this great survey of living constitutionalist scholarship. Could you, using that, sort of make the case for living constitutionalism? What are the most salient critiques of originalism that living constitutionalists have?
Yeah, a lot of our earlier episodes talked about different versions of critiques that living constitutional scholars have identified, and primarily because, as we talked about earlier, at least in our legal practice, living constitutionalism and originalism are often viewed as in opposition to each other, and I think that is practically true. And so one way I'd like to respond to your question is to kind of analytically try to fit together the different types of critiques that living constitutionalists have made. And I think there are 2 basic types of critiques. So one is a critique about originalism's methodology, and another type of critique is about originalism's substantive, the substantive outputs, the propositions that are outputted from originalist interpretation. And so when it comes to originalist process, one type of criticism is that originalism does not live up to its own claims. So originalism, for example, has claims about where there's fixed original meaning and we follow it. And some living constitutional scholars have argued that originalism by its own lights fails. And I think a really powerful recent piece of work on this point is by Richard Fallon. It's called the chimerical concept of original meaning. And there, in a previous episode, I went into more detail about that. What Professor Fallon effectively argues, or not effectively, essentially argues, maybe effectively, maybe not, is that there is no such thing as original public meaning, or at least there's no such thing as a fact of the world original public meaning. There can be public meaning, but it's going to require normative inputs, is his claim. A second critique, one that's more fundamental, is that originalism misunderstands how constitutional interpretation operates. And I had mentioned earlier Ronald Dworkin, and so Ronald Dworkin had a very elegant, a very powerful, by my lights, actually an accurate interpretation of some parts of our legal system, a theory called law as integrity. And his theory of law as integrity is you take the legal data, which is sociologically accepted in a legal practice. So in a common law course like property, which you've had, Aquila, you would look at the restatement propositions, you look at statutes in a particular state, you look at the common law cases in that state, and you'd ask, what set of legal propositions, what is the most moral interpretation of that set of legal propositions? And you get legal rules, legal standards, and then legal principles that are governing these entire bodies of law. And so from Dworkin's perspective, an originalist claim that you are looking for a fact of the world original public meaning is a mistake, because from his perspective, you always have to identify the morally best interpretation of legal data, and that legal data is susceptible to different normative interpretations. Another argument by Philip Bobbitt in a book called Constitutional Interpretation, his argument is what we would characterize as a pragmatic understanding of law. Law is the practice and only the practice of law. And Professor Bobbitt identifies what he calls different modalities. These are widely accepted conventions of argument in our legal practice. And his claim is that our legal practice is just the product of different legal officials using these different, I think he has 6 of them, 6 different legal modalities in their official capacities on an ongoing basis. There's no ultimate there that what the law is actually the current stasis of the legal officials' use of those different modalities. And originalism, which says there's a fixed original meaning, isn't doing that. So one set of criticisms is that originalism fails as methodology. The second set of criticisms is that originalism produces bad substance. And we've talked in some previous episodes about some of those criticisms. Originalism is inconsistent with democracy. Originalism is unjust. Originalism doesn't protect natural rights, is inconsistent with natural law. And for that criticism, Aquila, I think what what we would suggest is that originalist that our audience would look at some of the resources that originalist scholars have produced in response to that. I'm happy to give those in a moment as well. So the two basic criticisms: one procedural, methodological, and one substantive are the criticisms.
Right. And I understand that you've absolutely probably covered this ground, as you just mentioned, in the preceding 9. But if you could give us just like a sort of 30,000-foot, very quick view for someone who hasn't had the chance to join those earlier calls, what would you say like the basic originalist response to both of those types of critiques would be?
Yeah. So on the methodological response, which is something I don't think we've talked a lot about, well, a little bit off and on in our series. I think the way to think about how originalists approach the originalist methodology is, as over the last 25 years, originalists have developed by my lights, an elegant, a sophisticated, and a relatively complex approach to constitutional interpretation. In fact, it's so complex, or at least purportedly complex, that some critics have now taken to criticizing originalism as being kind of too complicated. It's kind of like the pre-Copernican Copernican view of the universe, right? There's like the epicycles and within epicycles. I don't agree with that criticism. I actually just think that American life is complicated, and we have a very complicated legal system governing 320 million people. So it would be surprising that there might be some sophistication needed to do it. So what originalists have done is they've identified a number of key mechanisms by which the project of originalism, which includes scholars, it includes attorneys, it includes judges, and also the president, Congress, and other folks as well, are able to work together to identify, articulate, and apply the original meaning. And I'll just give a couple examples. So when it comes to identifying the original meaning, of course, there are cases that you've read in your constitutional law courses, but there's also now a large and growing body of scholarship and scholars who, as at least a part of their professional identity, spend time researching, writing, and then debating with each other what the Constitution's original meaning is. And it seems like, and all I can do at this point is invite our audience to maybe take one area of law and read the original scholarship in that area, and I'll give some examples in a minute, and to see for themselves, do they think that this body of scholarship is, to some degree, not perfectly, but definitely more than imperfectly, not perfectly identifying with some degree of certainty the original meaning of whatever provision they're looking at. An example that I would pick as, I think, a very sophisticated area is the Privileges or Immunities Clause. So there's been scholarship on this now for about 30 years, and this scholarship has numerous scholars contributing to the scholarship and contributing to the debate. And I think we've kind of cashed out, not at a stasis yet. I think there's still evolution going on, but at a point where the scholars have come to a point where they agree there's large areas of consensus. So, for example, there's a consensus that the Bill of Rights is incorporated and applied against the states through the Privileges or Immunities Clause. There's areas of disagreement. So the scholars continue to disagree about whether, for example, unenumerated natural rights are applied by the Privileges or Immunities Clause. And then I think there's also some areas where the scholars don't have agreement on whether they agree or not. So there's this kind of true indeterminate area. And so what I would invite our audience to do is to read some of that scholarship and then to ascertain for themselves, do they think that there is a consensus, and is that consensus worthy of confidence for our legal system to employ? And who's doing the employing? It's going to be judges, right? So judges have busy lives, they got busy dockets, they're not experts at constitutional at originalism, but what they can do is they can rely on the scholarly consensus in their opinions, and of course judges get criticized. Just one example that I think has valence for our conversation. Justices Thomas and Scalia, for a long period of time, had argued that the 14th Amendment had outlawed, for the most part, race-based affirmative action. And one of the criticisms of Justices Thomas and Scalia was, you haven't given any originalist arguments for your position. I think that was a true criticism. That was a fair criticism. And in response to that, I think if you had read the Students for Fair Admission versus Harvard opinion, Justice Thomas's concurrence for the first time offers in judicial opinion, although it's been out there in scholarship for a while, a judicial articulation of his understanding of the 14th Amendment, especially the Citizenship Clause, that would outlaw race-based affirmative action. So you see right there, I think, an example of the iterative, constructively critical process that involves judges and scholars working together over time to identify, through that constructive engagement with each other and criticism, an original meaning.
Okay, I would like to actually hone in a little bit on that question of like judges doing originalism. And we have a great
Sure.
question for the audience on that point. So I'll just read it out to you and then get
Sure.
your thoughts. Let's assume that the claim that there are many judges who decide first based on what they think the outcome of a case should be, and then work backwards to the reasoning that they need. Does originalism add anything if the reasoning to get to that outcome is originalist in its basis? For instance, regardless of whether you're on the majority or the minority in DC, there's an argument that people came to that with their priors. And if that's the case, or if that occurs, is it possible that living constitutionalism could be more honest of judges, since they're just providing their bald-faced reasons, rather than sort of a pretextual originalist approach?
So that's a great question, and it's one that so in the legal world, you tend to have folks who are legal formalists and folks who are legal realists, and it's not a criticism at all. It's just to say that that's a relatively more legal realist perspective, which is we're kind of peeling back the formal data of the law that's in the opinion to see what's really going on, and we're looking at, as the questioner had asked, was Justice Scalia's majority opinion motivated by his political, ideological, jurisprudential viewpoint, and not the originalism, which was just kind of a later cover or window dressing for his previously arrived at opinion. And the same thing would go for Justice Stevens' originalist opinion as well. And so there's not a way definitively to, I think, evaluate that. So let me say a couple of things in response. When it comes to what originalism offers is a way to identify what the Constitution's original meaning is and to criticize people who don't arrive at that meaning or who don't arrive at that meaning. So let's say that Justice Scalia had, prior to writing the opinion, had decided that he was going to rule in the way that Justice Scalia had ruled, and then wrote the opinion with the motivated reasoning that the questioner is assuming. And let's assume as well that Justice Scalia's opinion was a correct or the best interpretation of the Second Amendment, better than Justice Stevens, for example. And in that case, I guess one might say that originalism doesn't add anything, but the claim by originalists is that if originalism is the right way to interpret the Constitution, there's an accident in this particular case of the coincidence between Justice Scalia's purported political views and the outcome. But it is just that, an accident, and that what the legal system is relying on is the original meaning is the correct identification, and whatever the motivation of somebody getting to it, if they arrive to the correct motivation, then they've done a correct, at least by legal lights, a correct action. Now, one thing that originalism adds in this situation, which has certainly been the case both before and after the Heller decision, is that originalism provides an opportunity for criticizing justices who arrive at non-originalist decisions for motivated reasons. So let's say that Justice Scalia had, actually I gave an example earlier in the affirmative action context. Justice Scalia had regularly ruled without giving any evidence from the original meaning, and people, including myself, had criticized him for not arriving at that conclusion. And I think that criticism is just. So, and going back to the District of Columbia and versus Heller context, a criticism by scholars of Scalia's opinion and also Justice Stevens' opinion was that they got the original meaning wrong. And what originalism offers is it can offer areas of scholarly consensus, and then if the judicial opinions are consistent with that scholarly consensus, then those are reasons to praise them. If they're inconsistent, then those are reasons to criticize them, regardless of the justice's motivations. And the last thing I would say, Aquila, is I disagree, I think, with one of the premises of the questioner, which was through living constitutionalism, you get honesty. I'm not sure if that's the case. So one of my favorite examples of this, I just taught it today, which is why it's fresh in my mind, is Everson versus Board of Education. So for our audience who hasn't read Everson, what you recall is that Justice Black wrote a very purportedly historically detailed opinion explaining why the Establishment Clause created a strict separation, a wall of separation, in his words, between church and state. When you look back at his conference notes, that's not what happened. It was definitely motivated reasoning. So that's a clear case based on the historical record of motivated reasoning by a justice who in his own mind was a living constitutionalist, and we didn't get honesty out of that. So I don't think that living constitutionalism gets us honesty, or at least necessarily gets us honesty, any more than originalism does. But what originalism purports to do is to say, here's the right way to interpret the Constitution and provide metrics for criticism. Because how could one criticize one? Well, we might get to this later. How can one criticize a living constitutionalist Dworkinian other than on the merits that you have an incorrect ethical theory, you have an incorrect philosophical understanding of what equality is? And maybe that's true, but those are much more, in my view, indeterminate debates than whether the original meaning of the Establishment Clause is X or is Y. So it's a great question, and I think that there definitely is evidence of motivated reasoning by all kinds of human beings, including justices, but originalism offers us a way to actually criticize and contain that in a way that living constitutionalism does not.
We have another question from the audience about interpretation when originalism runs out. So just to read the question, can the remaining modalities, besides considerations of the text, be useful when original meaning runs out? Can considerations like precedent or constitutional value become more useful when originalism is unenlightening? And just to add my own little bit to that question, when you do get to that sort of end stage ambiguity, is there any room for the sort of policy decisions that living constitutionalists might be making underneath an originalist framework?
Yeah, that's a really great question. So let me step back and situate where the question is coming from, or at least as I understand the question. So when it comes to originalist interpretation, you can think of there being roughly two stages. So one stage is identifying the fixed original meaning, and there are lots of areas where that's happened, right? So I mentioned the Establishment Clause earlier. I'm confident that the scholarly consensus is that the Establishment Clause is not a strict separationist clause. I don't think it's entirely settled on what the original meaning is, but it's narrowed the band of disagreement about what it is, and it includes at least something like a non-coercion principle, that the state can't coerce people to engage in religious practices or to believe in religious doctrine. Okay, and so that's constitutional interpretation. The original meaning is determinate, but there's another move, another operation that legal interpreters are often engaged in, which is constitutional construction. And constitutional construction includes at least when the original meaning is underdetermined, when it doesn't give one right answer. I'll give an example on that. There's a recent really excellent book by Philip Munoz dealing with the original meaning of the Free Exercise Clause. And what Professor Munoz argues is that there is a core determinate original meaning to the free exercise of religion, which is that the government cannot prohibit religious worship of Americans. But beyond that, his argument is, not saying I agree with it, but it's a very powerful and provocative argument, is that beyond that, the other kinds of regulations of the government of religiously motivated activity is an area of constitutional construction. And that's an area, in other words, where the original meaning doesn't say yes, but doesn't say no either. It's actually up to the relevant interpreter to decide. Okay, so most originalists agree that there is this phenomenon of construction. They disagree about who and what interpreters do in that context. So one proposal that's out there, and this is actually an earlier proposal by Professor Randy Barnett, was that judges are the primary constructors of constitutional meaning, and they have to utilize this is the subtitle to one of his books, a presumption of liberty. And so if that's the case, then going back to the question, one would use one's best conception of liberty in order to construct constitutional meaning. Now, Professor Barnett has since modulated his view, and I would characterize his view as being more constrained and less free-ranging. So in response to the question, there's a debate within originalism about what data is used by the relevant interpreter in the construction zone. My own view, for what it's worth, is that I think that our constitutional settlement identifies Congress, the president, or the states as the parties that have primary role when it comes to constitutional construction, and the judges have a subsidiary, secondary role, kind of filling in gaps in constitutional construction. And that comes from my view of the original meaning of judicial power, which is judges are not authorized to override other branch officials' constitutional constructions. Instead, what they can do is supplement and fill in gaps, and that's all that they can do. But there's lots of debates out there.
Great. You had identified earlier one of sort of the main veins of critique of originalism, whether or not it's possible to do originalism well. And I had a question that kind of builds off of that. A common critique of almost all interpretive approaches, right, is that it's hard for judges to do them well. So originalists argue that judges aren't equipped to be policymakers. They don't have that expertise. Living constitutionalists would argue that judges aren't equipped to be historians. They don't have that expertise. What would you say that living constitutionalist judges are good at? And is that harder or easier an approach than the history-based approach of originalist judges?
Yeah. I mean, I think what judges are good at is being lawyers, right? And so what is it that you are learning now in 3 years of law school? You're learning to be able to read cases. You're learning to use textual analysis. You're using the tool of structure as an interpretive tool. You look at history, both before and after the adoption of a relevant text, so a constitutional provision, a statutory provision. You look to tradition. So how has a constitutional provision been traditionally interpreted? And then you look as well at liquidation, kind of the filling in of gaps that has occurred. I think you see a lot of this actually in the early republics. When you look at the Marshall opinions, especially McCulloch versus Maryland, Marshall begins his opinion by talking about this is not a new issue, the issue of can Congress charter a national bank. It was done by the first session of the first Congress. President Madison had approved the chartering of the second bank of the U.S. And so his point, I think, is that the Constitution may have been, going back to our earlier conversation, underdetermined on the point about which whether Congress had the power in the necessary and proper clause to charter a national bank, but it's become determinate through this tradition of interpreting it in that particular way. So what are judges good at? I think judges generally are good at those lawyerly tools. And so how do originalists respond to the criticism that originalism is not what judges do? I think through two related moves. So one move is to identify originalism as fundamentally about the use of those lawyerly tools, uses of tools of text, structure, history, tradition, and precedent. And then, and when you going back to the earlier conversation we had about the Establishment Clause, right? So the Establishment Clause, there's a text there, there is history there, there's traditions of interpretation there as well, and all of those more or less, and sometimes less. So I want to acknowledge that, and there'll be my second move in a second. Are accessible to judges who are educated lawyers who are used to working with those tools. The second move is to say, and I kind of alluded to this earlier, that it's not just a judge or judges by him or herself, that instead what's developed over, especially the last 25 years, has been a really robust, iterative, thoughtful community of scholars who in different areas have worked to identify, articulate, and apply the Constitution's original meaning. And the Establishment Clause is one of those areas. I think the best book still in that area is by Donald Drakeman, Church, State, and Original Intent. And for our audience, if they wanted it as an example, Mr. Drakeman goes through and identifies the relevant historical material that everybody agrees on, identifies the three competing interpretations, and then comes to his own conclusion in that book. And so what do judges have? Judges have access to the scholarly community, and we call this the scholarly division of labor. It's not the job of the judges to identify as a matter of first order principle what the original meaning is of every provision. We actually have these scholars whose job it is to do that. And the scholars, as I talked about earlier, have created this iterative community where over time they've arrived at significant consensus or points of consensus, I'll say it that way, about what the original meaning is. Another example is the Commerce Clause. So I would invite our readers to read two pieces of scholarship. One is by Richard Epstein, and it's just titled Commerce. It's an older law review article where I think Professor Epstein does a really good job identifying the historical background and then the evolution of the case law. And then I think also Professor Barnett's book, Restoring the Lost Constitution, has a great chapter on the original meaning of the Commerce Clause. And I would invite our audience to read those provisions, and then you can see the kind of detail and debate that scholars use. And then when you look at Justice Thomas's concurrence in the Lopez case, for example, which was the first judicial pronouncement of an engagement with the original meaning of the Commerce Clause, at least in the modern era, you can compare and contrast to what degree is Justice Thomas consistent with this scholarly consensus or not, as the case may be. I think he was for the most part. And so you can see, I think, in that context, an example of the scholarly consensus, and then judges were relying on that scholarly consensus to support their decisions. So one last point was, all these questions are relative, right? So you asked about originalist judges and also living constitutionalist judges. And there are some living constitutionalist ways of doing things that I think are relatively accessible for lawyers. So I mentioned earlier David Strauss's The Living Constitution, which is a common law constitutionalism. And going back to what I said earlier, the thing that we're teaching you as a law student, as young lawyers, is how do you do case crunching? And so if the Constitution, in fact, is what the Supreme Court has said it is, which is what common law constitutionalism says it is, then that is something that I think lawyers can do really well. So I think there are living constitutionalist moves that can be done well with the tools that lawyers have. Other ones, not so much. So I mentioned earlier Ronald Dworkin's theory of law's integrity. Identifying the morally best interpretation of equality is typically not what lawyers are trained to do, even though we're smart people and we may have some insights into it. So I think there are other versions that are harder to do. So on balance, I think that originalism relies on the tools that judges have, but then gives them access to these other scholars who have the time and talent, and then the community to be able to identify a consensus.
I have a couple questions specifically sort of temporally limited to the framers and originalism. One of them comes from the audience. So it's if we conceptualize separation of powers as something inventive and new by the framers, is originalism useful in separation of powers questions? In comparison, originalism is likely more useful for individual rights since they're meant to be codified in their form that existed before ratification. So any thoughts on that?
Yeah, that's a great question. So I guess I don't think it matters to my answer, but I don't know if I agree with the premise or one of the premises, which is that the separation of powers is new. So the framers ratifiers read Montesquieu's Spirit of the Law. The Spirit of the Law was purportedly based on, I think semi-accurately, based on the English, the United Kingdom's system of government, which had three different branches. Now, we took it to a new level for good or for ill. People have criticized it, of course. So I don't know if it's necessarily new, but even if it is new, I'm sorry, even if it, yeah, even if it's not new, or whether it's new or not, I think is not necessarily relevant to whether originalism can utilize it. So let's say that the separation of powers is a proposition that we can discern from the Constitution, which I think most people think is the case. There's a new book coming up by Richard Primus from Michigan, which pushes against that. So I just want to acknowledge that there is pushback against this position. But the vast majority of our practice thinks that there is a separation of powers. The separation of powers typically means that each branch of government has a particular type of power, legislative, executive, judicial, and that branch can't do the other branch's powers unless there's a specific constitutional authorization to do so. And whether that's new or old, I think isn't relevant to the help that the separation of powers gives to constitutional interpretation. So, for example, when it comes to the free exercise clause, or the establishment clause for that matter, or the religious test clause for that matter, right? There's three different clauses dealing with religion in the Constitution. Each of those in some ways is a limit on the federal government and then maybe later the state governments as well. And so what it tells us is it gives us some information about what the authors and ratifiers were thinking, which is religion is something valuable, religion is something that the government likes to be involved in, and the Constitution is prohibiting lots of different involvements between religion and the government. That doesn't answer all questions, right? There's lots of questions that remain open, but it does give us some information about what those meanings are. Or think about, for our audience who's read NFIB versus Sebelius. So the real work in answering the question presented under the Commerce Clause, does Congress have the power under the Interstate Commerce Clause to require Americans to purchase government-approved health insurance? The real work being done in that case was by the principle of limited and enumerated powers. And whether that was new or old, the principle still gave sufficient information for a majority of the justices to come to the conclusion that that interpretation was not a correct interpretation, not necessarily because of the original meaning of the Interstate Commerce Clause, through like a de novo review of that original meaning, but because of the principle of limited and enumerated powers would be violated. So I don't think the newness or oldness it matters to the value that these principles bring.
Another argument is that originalism doesn't really seem to be the method of interpretation that was prevalent at the time of the founding. You know, whether we're looking to sources like Blackstone's commentaries, or figures like Thomas Jefferson, who very famously thought the Constitution should be ratified and amended every 20 years, a new Constitution for a new generation. So with that taken into account, doesn't living constitutionalism rather than originalism maybe align better with how the founders thought about the Constitution and interpretation?
Yeah, I'll say two things, maybe three things in response to your question, Aquila. So one, I like Thomas Jefferson as much as the next guy. I've been to Monticello. It's an amazing place. The Declaration of Independence is a beautifully written document. It's a statement of our constitutional principles. But in a lot of areas, Thomas Jefferson was an outlier. And I think this is one of those areas. He was an outlier in the Establishment Clause. I was just teaching that again today. And this is another area where he was an outlier. So he wrote famously wrote a letter to his friend James Madison while the Philadelphia Convention was going on. Jefferson was in France, and basically making the claim that you were making, Aquila, which was Jefferson was saying, hey, you guys can't lock this stuff in. It's unjust because the earth belongs in usufruct to the living. And Madison didn't listen, and nobody else listened as well. So I think that the view that Jefferson was articulating was not the predominant view. And instead, the predominant view was, we, the United States, under the Articles of Confederation, have faced some major challenges, some existential challenges, honestly. The Union was on the point of breaking, and we needed a new, relatively determined long-term solution to the problems that the fledgling United States was making. Madison in the Federalist Papers argues about how long usage will give credence and then kind of honor to the Constitution. Our national motto is Novus Ordo Secularum, so a new order of the ages. So they intended this thing to last a long time. And so I think the conception at the time was that this was going to be a long-lasting document. And so then going to the other related part of your question, well, what was the theory of interpretation that was dominant at the time? And original scholars, including myself, have gone back to the historical materials contemporaneous with the framing ratification. And the argument that original scholars have made, I'm persuaded by it, is that something without the label originalism, but substantively similar or identical to originalism is what was operative at the time. So two books that I would recommend, one by Christopher Wolfe, which is the Rise of Modern Judicial Review, and the other by Jonathan O'Neill, Originalism in American History and Politics, I think is the title of it. And both of them spend time during the early framing ratification with the American legal system. There's a great article actually by Jefferson Powell, H. Jefferson Powell, 1985, 1986, The Original Understanding of Original Intent, where he makes the argument, it was widely taken to be making the argument that originalism is inconsistent with the expectations of the framers and ratifiers. But actually, I think when you read the paper, this is now the consensus, what he was making the argument was that it wasn't an original intent motivation, it was an original meaning motivation. And the last piece of evidence I would give, which is common to all of these different sources, is Blackstone's own rules of interpretation. So William Blackstone famously wrote the commentaries on the laws of England. There were actually more publications of that book in the United States than in the United Kingdom. Americans just loved that book for some reason. And he had rules of interpretation for parliamentary statutes. And those rules of interpretation looked a lot like rules that originalists would follow today. So I think that's a long way of saying that I think the framers and ratifiers actually thought that something like originalism would be the theory of interpretation that was used. Now, it doesn't mean that everything was determinate, and it doesn't mean that that there were all answers, right? Because we previously talked about there are lots of situations where the original meaning is underdetermined. But I think that that was their default way of thinking, how are American officers going to interpret it in the future?
We're coming up on time, so I think I have one more question if you have the bandwidth for it. How can legal principles grow over time in an originalist framework? Absent the finding of new historic information, isn't originalism too inflexible? Whereas, the benefit of a living constitutionalism, it does allow legal principles to grow over time.
Yeah, that's a common juxtaposition, and I think probably practically a correct one in a lot of ways. So when you think about, I hope this isn't consistent with your question. I might just broaden your question a little bit, which is, how is it that originalism views implementing the Constitution? So one way the Constitution gets implemented is through, this is more focused on your question, changing constitutional principles, or maybe changing application might be a way I would say it. So one is on a constitutional level, but then I want to broaden the perspective and talk about on a sub-constitutional level as well. So my vision of originalism is that it's the way in which we interpret the Constitution, which includes the Constitution proper, but also the ways in which the Constitution properly interpreted authorized other officers to create sub-constitutional rules. So on the constitutional level, there is, I think most importantly, the doctrine of precedent. So most originalists agree that there's a doctrine of precedent. Now, it gets controversial when we talk about non-originalist precedents, to put that up on the side. But most originalists think that originalist precedent is a key way in which the Constitution's original meaning is implemented. So I'll just take one example from the Commerce Clause. So the Commerce Clause, if you've taken the Commerce Clause, you've read Gibbons versus Ogden, but between Gibbons versus Ogden, where most people read, and then NLRB versus Jones and Laughlin Steele in 1937, which is the New Deal case, there was actually a lot of case law going on, and most of it, I'd say almost all of it, was consistent with the original meaning. So what was going on there? The Supreme Court was being faced with new factual scenarios and was being asked to apply the Interstate Commerce Clause's original meaning to those factual scenarios. And the product of those cases and holdings was a series of doctrines that developed, and it's the doctrines themselves that were the implementing mechanisms of the original meaning. So part of the way in which originalism was flexible is that it's applying to new and unforeseen circumstances through this process of creating originalist precedent. So that's one way. Second is constitutional construction. So in the areas where the Constitution's original meaning is underdetermined, the relevant interpreter can construct constitutional meaning in light of current circumstances, in light of current needs. Third is non-originalist precedent. That's a little bit more controversial, and it's a little bit kind of in the weeds, but there's a way in which, to the extent that originalism allows for the continued existence of non-originalist precedent, one of the products is that if that non-originalist precedent is one that's responding to new and changing circumstances, then it continues to be viable and continues to respond to those new circumstances. So that's at the constitutional level. But when you think about what is Congress doing, Congress under Article 1, Section 8 and a few other provisions, it's creating lots of applications of the Constitution. It's creating lots of implementations of the Constitution through statutes, the executive branch through rules, and then the federal courts through, and this is controversial, but through federal case law interpreting not just the Constitution, which I talked about earlier, but federal statutes, federal administrative regulations, and to some degree, federal common law. And the same thing is happening on the state level. So the picture I want to paint is not focused just on the Constitution's text, which is important, but in all the ways in which the Constitution creates law that allows our political community together to pursue the common good through sub-constitutional means as well. So it's actually kind of a really, my point is, it's a really rich picture, Aquila.
Thank you so much, Professor Strang. I fear we're probably at the end of our night. Before I let you go and wrap things up, are there any final either comments or questions that you'd like to address?
Yeah, thank you, Aquila, for hosting this last kind of capstone episode of the series, which deals with the phenomenon of living constitutionalism itself. And one of the things that I hope has come across in the series is that there's a robust, vibrant debate going on regarding American constitutional interpretation. There are reasonable scholars who are proposing originalism. There are reasonable scholars criticizing originalism. And one of the things that I've hoped is that we've offered enough of the arguments to show people that there are reasons to go and investigate for yourself the different scholars on the different sides on these different issues. So thanks for contributing to that tonight.
Well, no, thank you. And a thank you to everybody who attended tonight. I hope you've all found these sessions to be as fruitful and interesting as I have. A special thank you to everyone who's been tuning in for all of these sessions. And if you've enjoyed these webinars, you can always keep up to date with other Federalist Society events at fedsoc.org. Thank you again. And Professor Strang, thank you for sharing your time and your wisdom. All right, have a great night.